sorry for that. I don't know. So I got like a notification that this meeting is being live streamed, and I just clicked like on the X on that notification, and I automatically left the meeting or something.
Oh, I see.
So I was like, okay.
Yeah, no, you just, I just got it. You could, if it comes up again, you can just say got it. You don't need to leave the meeting.
Yeah. That's what I saw, that I have to press got it.
And I've actually paused the live stream.
Do obs know how to move? I think they should. I'll just go anyway.
So yeah, let's get the teams into the main room now. Steve, hello.
Hi, Chris. How are you?
Sorry for putting too many obstacles in the way.
No, the thing is funny because we've all gotten so good at the video conferencing, but I jinxed it by being on an event Friday saying how good we'd all gotten. So I guaranteed that Zoom decided to give me a test.
We put this security obstacle in there because unfortunately last year hosting a Zoom meeting, we had a Zoom bomber.
Oh wow!
With obscenities and swastikas and things like that. So I'm very paranoid about it now.
Wow, I've heard of this, but I've never actually experienced it. You've had the full pleasure.
We had it, and it took us about 5 minutes to get him out, and it was just unpleasant experience for everybody. So yeah, the people stumble over it as well, that we require them to be logged into an account when they join, and so it's all good.
Yeah, no, the thing is I am in an account, and that's why I don't understand why the default didn't work, but I got it all sorted out, and I now have a new password, and I use and it refers to Africa because I was blanking on anything interesting, so I'm just putting it into my contacts so I remember it.
Ah, excellent. I see. I'm in with you guys now. For a second, I thought you were with me, but Aronima just moved me magically. So are you guys ready to go for it? I think you have a chairwoman, and you know what the drill is. So I will step out. I'll introduce the teams, and then when you come in, I'll introduce you very briefly, but invite you to introduce yourselves.
Chris, just one quick question before we do that, because I'm not entirely paying attention, but how long are we giving them?
Each team has 40 minutes to plead. No counsel should plead less than 15 minutes, and therefore none more than 25. They can reserve up to 5 minutes within those 40 for rebuttal or surrebuttal. Great,
thank you.
Yeah,
Chris,
okay.
One more question. There will be a secretary moving teams in and out once we.
Yes, yeah. Once you're finished with the hearing, we'll move you back in here so you can deliberate in peace, and they can either wait there, or we can move them back into a waiting room for them
we
to
will be moved to chambers because this is live. Okay.
Yeah.
Thank
so
you.
You can have complete confidence. No one will be listening. So I'm going to hop out of here again. Oops. Okay. There we go. So I'm going to go.
Chris, I believe you're still muted. I'm not sure if anyone can hear me.
Thank you. Can I ask the can I ask, please, that the team members who are not pleading, so the coaches and the observers, to mute their video and audio? I would also ask the judges, with respect to the best advocate of the final, to also mute their video. So that would be James, Noor, and Carol. And then let me briefly introduce our honorable tribunal today. First, I'd like to introduce Mr. Steve Finizio from WilmerHale, Mr. Dimitri Diakin from
Balkan Garcinian and Partners.
Thank you. I was going to mispronounce it. I'm sorry about that. And Megan Vestby from from Global Affairs Canada. She's a trade lawyer there and one of the committee members that designed this year's case. I'd invite the arbitrators to introduce themselves a little bit more, and then also invite the team members to introduce themselves briefly. And with that, I'm going to turn it over to Megan, who I believe will be presiding today.
Thank you, Chris. Okay, so Dimitri or Stephen, whoever, if you'd like to just start us off on kind of a deeper introduction, that'd be great. Thanks.
Dimitri, you want to do it?
Okay, thank you, Steve. My name is Dimitri Diakin. I'm a partner with Russian law firm Rebuttal, Garcinian and Partners, and I'm co-head of international dispute resolution practice. I'm basically based in Moscow, which is far away from your home countries, I guess, and mostly practice international arbitration and international litigation. Steve.
Thanks, Dimitri. My name is Steve Finizio. I am a partner at WilmerHale. I'm based in London. Some of you may suss out from my accent that I'm not English. So I'm trained as an American lawyer, and I do think it's useful to know people's backgrounds when you're pleading to a tribunal. I have a focus on both commercial and treaty arbitration, and I sit as an arbitrator, but primarily act as counsel and have the pleasure to be co-counsel actually with Dimitri. I didn't know Dimitri was going to be here today in a treaty case. And so anyway, I think it's enough about me. And I'm actually looking forward to hear from you all.
Thanks, Stephen. And my name is Megan Vestby. I practice in Ottawa, Canada, as Chris mentioned, for Global Affairs Canada. My practice mainly consists of international trade law, where I work on market access and trade remedies cases for Canada. I am an alumni of the FDI Moot, and happy to mention that, and also a member of the drafting committee for this year's problem. So looking forward to hearing how the teams argue the problem. It is my first round hearing teams argue our problem live, so I'm very excited to hear what the teams argue today. So with that said, I believe I can start off by asking if the teams have agreed on how they'd like to begin today.
Good afternoon, Madam President, members of the tribunal. I confirm that we have agreed, and the respondents are at liberty to confirm this. We have agreed on our order of argument.
So with the order of argument then, do we have the respondent going first and the claimant going second for the first two? And what's the time allocated with, I'll just ask the respondent to speak for, sorry, I believe I have R1.
Yes, Madam President. The time allocation for the respondents is 18 minutes for the main arguments and reserving 2 minutes for rebuttals and rebuttals. As for the claimants, they proposed that the first speaker will speak for 16 minutes, reserves 2 minutes for rebuttals, and then the second speaker will speak for 20 minutes, and they also reserve 2 minutes for rebuttal and rebuttal, yeah.
Okay, so I have 18, 16, 20, and the last respondent. I don't see you on my screen, but I believe you're there.
The last respondent will also speak for 18 minutes and reserves 2 minutes for rebuttal. Rebuttal.
Okay, let's just confirm this. So respondent, 18 minutes, the first speaker, 2 minutes for rebuttal, then the claimant, 16 minutes, 2 minutes. You have 40 minutes total, so perfect, 20 minutes, 2 minutes for claimant 1, respondent 2, 18 and 2 minutes. Please let me know if I've made a mistake. Okay.
No, that's fine, Madam President.
Okay, so respondent 1, the floor is yours.
Thank you, Madam President. Members of the tribunal, receive our warmest greetings. My name is Effie Okola, lead counsel, and with me is my co-counsel, Sharon Nyaga. In the next 18 minutes, I will address this tribunal on the procedural issues, that is, the tribunal's jurisdiction and the admission of amicus submissions. Members of the tribunal, in Greek mythology, a story is told of a young boy by the name Icarus, who in service of his own ego and in defiance of his father's warning, flew too close to the sun, causing him to fall to his death. Equally, in the matter before this tribunal, the claimants, having realized their targets fairly early in their term, began to make reckless decisions against the advice of the respondent's representatives. This not only led to the airline incurring losses, but also losing its standing in the Greater Nanyang region. What we shall show you in our submissions is that first, the matter before this tribunal is not within the center's jurisdiction, and second, that the consortium of Bondru foreign investors have not met their admissibility requirements to file amicus submissions. On jurisdiction, we submit that the matter before this tribunal is not within the center's jurisdiction as the claimant acted as an agent of its state. We guide this tribunal to Article 9.1 of the SEPTA on page 73 of the record from line 2589, which begins with the words investor means. And it reads, an investor means a natural person with the nationality of a party or an enterprise with the nationality of a party or seated in the territory of a party that seeks to make, is making, or has made an investment in the territory of the other party. We note that this definition does not include state actors or state agents. At this point, we would like to point out to the tribunal that we do not contest the nationality of the claimant, but rather dispute that the transaction before this tribunal, that in this specific transaction before this tribunal, they acted as an agent of the state of Bondru, and thus the dispute before this tribunal is between two states. And as provided...
Sorry to interrupt you there, I'll just get you started on this. So your position is that Article 9.1 of the treaty doesn't explicitly include state-owned enterprises, but anywhere in the text, or maybe you could point me to something else, where it expressly prohibits a state-owned enterprise from having standing.
Madam President, we submit that there is no explicit prohibition of state-owned enterprises. However, the definition of an investor is specific. In this regard, we do not dispute that the claimants, as a private enterprise, could have made an investment. But however, our contention is that in this particular transaction that they claim they made in the state of Mekah, that they were pursuing the objectives of the state of Bondru, and as such were acting as an agent of the state of Bondru, and therefore this tribunal does not have jurisdiction as the dispute is between the state of Bondru and the state of Mekah.
Okay, but so I'm following that they are acting as an agent for the state, but where does it say that, like when I'm reading Article 9.1, the definition includes the nationality of the party. And in my eyes, or how I'm understanding it, even if it were a state-owned enterprise, how does that affect the nationality? In my mind, it still falls within that definition.
Madam President, we agree with you that the definition of an investor looks to the nationality. And in this regard, we do not contest the nationality of the claimants, but what is at dispute is that in the operation of Kaili Airways, that is the respondent's national flag bearer, that they operated this transaction in pursuit of the objectives of the government of Bond Rule, and therefore the dispute before this tribunal does not relate to that of state investor dispute as provided in Article 2 of the Additional Facility Rules, read alongside Article 25(2) of the ICSID Convention.
So if I may jump in, many of the things that they were doing were what any commercial airline would do. So can you give us more detail as to why it is that you say they were acting in pursuit of the agenda of the state?
Yes, Mr. Arbitrator. Your question actually speaks to the heart of our submission. That is that the claimants in operating Kaili Airways were actually pursuing a governmental function. We rely on the definition that was laid out in the case of Maffezini versus Spain by the ICSID Tribunal in the year 2005, where they stated that governmental functions are those that are reserved for the performance, whose performance is reserved for the state, or is not performed by private entities or not performed by private individuals. It is our submission that although they were pursuing a commercial interest, that this does not prohibit this tribunal from finding that they were pursuing the objectives of the state, as was stated by the tribunal in the case of Maffezini at paragraph 80. And I shall read.
Well, if I can interrupt you, I mean, because we're blending together different things. You're talking about the Maffezini test, but you also are talking about just pursuing interests of the state, which isn't the Maffezini test. The Maffezini test, as you've articulated, is a purely governmental function. So doing something that's in the interest of a state and is also commercial is not the same as doing something that's purely a governmental function. And so you're making broad arguments. What are the specific facts you're relying on to say that what they were doing was, for the sake of argument, assuming your standard is correct, a purely governmental function?
Mr. Arbitrator, to respond to your question, we submit that there are three specific events at which the claimants were indeed pursuing a governmental function. The first is their participation under the Horizon 2020 scheme. We guide this tribunal to paragraph 32 of the record, or my apologies, page 32 of the record, the second last line, which begins in its application. It is stated that in its application, Vema Holdings Incorporated specified that it would use Kaili Airways to invite tourists from Mecca and the Greater Nanyang region into Bondru's emerging tourist market. Our submission is that had the subsidies that were granted under the Horizon 2020 scheme been given to the claimants to use the Royal Nanyang, which is the national airline of the state of Bondru, there would have not been a point at which we would have argued that they were pursuing a governmental function. However,
let me come back to where I was though.
Yes.
Pursuing a state interest, being even a state-owned airline, assuming they are, and I'm not sure they are, when does that, you're relying on a test that talks about a purely governmental function. And I think you're blurring the distinction between things that are in the interest of the state, which might be to increase tourism, which also would be in the interest of a commercial carrier in a state, and something that would be reserved entirely and only for a government entity. And that's what I'm not hearing is, what did they do that would be reserved only for a governmental entity? Not something that pursues a state interest as part or in whole of what they were doing, but what was reserved for a governmental entity that they were doing.
Mr. Arbitrator, to respond to your question, we shall rely on the case of BUCG versus Yemen of 2017, where the ICSID Tribunal, in determining whether BUCG was discharging essentially governmental functions, considered the circumstances under which the contract was terminated. In the case of BUCG, the tribunal held that BUCG could not have been seen to be a governmental agent or discharging essentially governmental functions, owing to the fact that the reasons why the contract was terminated was due to non-performance, which is different from the fact before this tribunal, as it is stated that at the conclusion of the first investigation by the CCM, it was found that the participation of the claimants under the Horizon 2020 scheme enabled them to participate in anti-competitive behavior,
Okay,
which is against.
But we're just let me just ask you to do it, and then I'll let you move on. Can you give me one or two or three examples, purely factual? Don't rely on other cases. But what were the three things? I think because I think you referred to three things that the airline was doing that were governmental, the sorts of activities that are normally reserved to governmental entities.
Very well, Mr. Arbitrator. To this, we respond that the claimants, in enabling the mobility rights of the citizens of Bonnroo that is enshrined in Article 70 of Bonnroo's constitution, in operating routes between Mekah and Bonnroo, was their participation of a governmental function. We would like this tribunal to note that the provision of the mobility rights of the citizens of Bonnroo was predominantly performed by the state of Bonnroo up until the point that it decided to privatize BA Holdings. This role was primarily performed by the state of Bonnroo and reserved for the state of Bonnroo. Therefore, the claimant's participation in enabling the mobility rights of the citizens of Bonnroo was them discharging an essentially governmental function. We would like this tribunal to also note that they continued to fly these routes despite the fact that they were incurring significant losses. This is found in paragraph 33 on page 33 of the record. We would like this tribunal to find that the claimants were indeed discharging essentially governmental functions, owing to the fact that their participation under the Horizon 2020 scheme, as well as in providing for the mobility rights of the citizens of Bonnroo and in providing significant funds specifically only to the routes between Mekah and Bonnroo, despite them incurring losses, is proof that they were performing governmental functions, and therefore this tribunal lacks the jurisdiction to hear the matters before it. If there are no further questions from the tribunal, I will now proceed to our submissions on amicus. Without prejudice to my foregoing arguments, we submit that this tribunal should not grant leave to the consortium of Bonnroo foreign investors for two reasons. The first being that the consortium of Bonnroo foreign investors do not bring a different perspective before this tribunal, and the second, that their independence is in doubt. With regards to the first claim, which speaks to them not offering this tribunal a different perspective, we submit that under Article 9.19, sub-Article 3 of the SEPTA, it is provided that this tribunal may admit amicus submissions where these will assist it in making a determination on the issues, or rather the arguments of the disputing parties. This is similar to what is provided in Article 41 of the Arbitration Rules 2006, which states that non-party submissions may be admitted where these will help the tribunal in making a determination on a matter of fact or law, and shall take into consideration whether these petitioners will offer the tribunal a different perspective. We submit that according to the exit tribunal.
Can I stop you for a second? Where does you've elided from a standard that said will help us to one that requires it to be a different perspective? And can you flesh out why it has to be a different perspective?
Yes, Mr. Arbitrator.
Because it may be that the same perspective, but in more detail, could assist us as well.
Yes, Mr. Arbitrator. We submit that according to the case of Philip Morris versus Uruguay, it was stated that where submissions are similar, it does not mean that they do not offer a different perspective. However, in the case of UPS versus Canada, a case decided by an exit tribunal, it was stated that where the tribunal finds that the competing arguments can be sufficiently discussed by the disputing parties, this could be grounds for the petitioners not to be granted leave. It is our submission that the CBFI intend to make submissions with regards to the standing of state-owned enterprises before this tribunal and the test to be applied, which looks at the nature of activities done and not the purposes that they serve. We submit that we have already made submissions with this regard and have applied this exact same standard that they wish to propose to this tribunal. Therefore, the submissions that they will make before this tribunal cannot be held to be different from that of the respondent. And we also note that the claimants may make similar submissions, and therefore this tribunal should find that the consortium of bond foreign investors shall not offer this tribunal a different perspective.
Is there a downside to us hearing from the amicus? Is there something is there a prejudice or some harm that would come from this? So and is that relevant to the test?
Mr. Arbitrator, your question actually moves me to my next point, which would be that in any case, if this tribunal finds that the perspective offered by the consortium of bond foreign investors would be different, that their independence before this tribunal is in doubt. According to the tribunal in the case of Aguas Provinciales, there are 3 requirements that an amicus must satisfy in order to make amicus submissions. The first is that they must have the requisite experience. The second, that they must have the required expertise. And finally, that they must be independent. The standard of independence was laid out in the case of Von Pezol versus Zimbabwe in the procedural order number 3, where the tribunal stated that where the arguments of a petitioner can be seen to be clearly aligned to one of the parties, this would transform them from being an amicus of the tribunal to being an amicus of the party. We submit that in the present case, this is the situation that the consortium of bond foreign investors find themselves, owing to the fact that 38 of the members of the consortium of bond foreign investors are currently investors in MECA, and 2 of whom are currently pursuing claims against the respondent with regards to the same violations that the claimants present to this tribunal. In addition to this,
sorry to interrupt you.
Yes,
in the case you just cited in support of your argument, was the tribunal applying the UNCITRAL rules on transparency?
Madam Arbitrator, we submit that in the case of Von Pezol versus Zimbabwe, the tribunal was investigating Rule 37 of the institution rules, which provided that when amicus submissions are made to an exit tribunal, that the petitioner ought to be independent from either of the parties in order for them to make a submission that would assist the tribunal in making a determination and not skew the object. My apologies.
What were the institutional rules in that case then?
We submit that the institutional rule was that the amicus had to be independent, and this would speak.
Just the name of the title of the rules. What rules were they operating under? And I want to know, and why I'm asking is how they differ or how they would be impacted by the UNCITRAL rules on transparency, which we have been asked to apply in this case.
Madam President, we submit that this were the exit institutional rules of the year 2006, Article 37, which is similar to that of Article 41 of the arbitration rules 2006. With regards to the second part of your question, which speaks to the effect of the application of Article 37 of the institutional rules on the UNCITRAL rules of transparency, we submit that they would not interfere with the rules of transparency that the respondents urge this tribunal to apply.
They may not interfere, counsel, but correct me if I'm wrong, UNCITRAL rules on transparency means let more amicus in, it increases, well, some may say, the public interest of greater transparency. So what I'm kind of wondering is if the UNCITRAL rules are put in place or adopted and are being applied after this case was rendered, I'm not sure the date of the case you're raising, would that principle still be relevant? Because we have an investment arbitration is changing and there's a shift towards increased transparency in the proceedings.
Very well. Before I respond to your question, I see that my time is about to lapse, and I would like to request an additional 2 minutes to respond and conclude our submissions. Thank you, Madam President. We submit that the same question arose in the case of Von Pezol versus Zimbabwe, in which the tribunal stated that although transparency calls for tribunals to admit more amicus to increase the transparency in regards to public interest, that this should not be admitted at the detriment of another party. It is our submission that due to the alignment that the Consortium of Bond Foreign Investors have with the claimants before this tribunal, that their submissions will be aligned towards one side of the argument, and therefore this tribunal cannot rely on those amicus submissions in determining whether it indeed has the jurisdiction to hear the matter before it. It is therefore our submission that owing to the fact that the Consortium of Bond Foreign Investors do not offer this tribunal a different perspective, and in addition to this, that their independence is in doubt, this tribunal should not grant leave to the Consortium of Bond Foreign Investors. With this, Madam President and members of the tribunal, I yield the floor back to the chair.
Thank you. Okay, Claimant 1, you have the floor.
Good afternoon from this side of the world. My name is Grace Jelimo, and I shall be submitting on the first and second issues. On the first issue, I shall be submitting in regards to jurisdictional matters, and on the second issue, I shall be submitting in regards to admissibility of the amicus submissions. On the first issue, the claimant submits that this tribunal has jurisdiction over the present claims before it. I shall not be submitting in regards to material jurisdiction as the respondent has not contested. However, in regards to personal jurisdiction, it is our submission that indeed this tribunal has personal jurisdiction over the claims present before it. I shall be submitting on two limbs of arguments. That firstly, the claimant is an investor within the meaning of Article 9(1) of the SEPTA. And secondly, that the claimant is not a state-owned enterprise. On the first limb of arguments, it is our submission that Article 9(1) of the SEPTA defines an investor to mean an enterprise with the nationality of a party that seeks to make an investment in the territory of another. An enterprise of a party has been defined to mean under the SEPTA one which has been constituted under the laws of that party and has substantial business activities in that party. It is our submission, members of the tribunal, that pursuant to the notice of arbitration, it was clearly stated that Vema Holdings has been incorporated within the laws of Bonuru. Additionally, members of the tribunal, pursuant to the Memorandum of Association, it is clear that Vema Holdings has substantial business activities within Bonuru. This is pursuant to Article 3A of the Memorandum of Association, which explains to us that Vema Holdings is a national airline. That means that it has substantial business activities within Bonuru. On the second limb of argument, it is the claimant's submission that this is not a state-owned enterprise. I shall be relying on the two-tier test that was set out in the case of Salini Constituri versus the Kingdom of Morocco. In this particular test,
I'm going to stop you there. So I'm going to pose the same question I asked to your co-counsel. If this tribunal finds that the investor is a state-owned enterprise, does that mean that there cannot be jurisdiction in this case? Just yes or no, and what's your authority for that?
No, especially because they have the SEPTA does not contemplate for state-to-state arbitration, and this matter has been brought through the ICSID additional facility rules as well as the SEPTA.
So where in the additional facility rules does it preclude state-owned enterprises?
Particularly Article 2 of the ICSID additional facility rules.
I have it here in front of me, counsel, and I don't see where it says cannot be state-owned enterprise.
It provides that the matters would apply between a state and a national of another state. Therefore, it is our contention that in regards to a national of another state is not a state-owned enterprise.
Okay,
And
so
within
the national can't be, so your first argument was you were convincing this tribunal that the claimant is in fact bears the nationality of the host or of the state of Benoru. So now you want us to define or to interpret national in Article 2 as being a legal person and not a legal entity.
it would be my response that our submission is that it is not a state-owned enterprise, because within the sector specifically, state-owned enterprise do not have a legal standing, and that is where the difference would occur.
Okay,
In light
I'm now a bit confused. I hear you saying that a state-owned enterprise doesn't qualify as an investor under the additional facility rules or SEPTA. And I assume you're going to go on to argue that this is not a state-owned enterprise. But that's not really responsive. I'm putting aside whether that's right or wrong, and I have my doubts as well as to where the additional facility rules bar a state-owned enterprise or why you'd want to argue that. The argument we heard from the respondent was that it wasn't really about who owned it, but how it behaved. And so I hadn't heard you in your outline of where you were going really pick up the argument that the respondents made, which is to say, regardless of what the ownership structure is, this is acting as a state organ. And that's why it falls foul of the limitations and the additional facilities rules, presumably in SEPTA as well. So are you going to pick up the point as to the nature of the entity and its behavior as opposed to the ownership structure?
Indeed, Mr. Arbitrator, I shall equally be relying on the broad-chest test in my subsequent arguments that it is important to note the nature of activities and not the purpose of the activities.
Okay.
Moving on to my arguments, pursuant to the Salini two-tier test in regards to the functional characteristics and the structural characteristics of a state-owned enterprise, it is the claimant's submission that this does not qualify as a state-owned enterprise. The Salini test mirrors the ILC draft articles under Article 4, 5, and 8. In regards to functionality, we shall look at the state-specific functional powers, and in regard to the structure, we shall look at the organic structure, whether it is a state organ and whether it is effective control. In light of that, members of the tribunal, the functional characteristics were set out in the broad-chest test, whereby Aaron Broad-chest set out a test in light of which was applied in CSOB versus the Czech Republic, which explicitly stated that in determining a state-owned enterprise, the focus will be on the nature and not the purpose of the functions. I shall leave this tribunal to Annex 3, that is in regards to the Memorandum of Association of Vema Holdings. The Memorandum of Association of Vema Holdings explicitly states under Article 3A.
Can you give us a page number and give us a second to follow you?
Okay. Page 44. That would be Article 3A of the Memorandum of Association of Vema Holdings. Pursuant to Article 3A, the objectives are to establish a national airline and air transport undertaking to provide air transport services for passenger, cargo, to carry out all other forms of aerial work, and to carry on any other trade or business which is calculated to facilitate or is auxiliary to or associated with such a business. It is our submissions, members of the tribunal, that the governmental functions that were performed are auxiliary. However, the main functions that are being performed by Vema Holdings are commercial in nature, members of the tribunal. In regards to the structural characteristics, members of the tribunal, we shall look at the shareholding, and pursuant to paragraph 10 of the Statement of Uncontested Facts, that would be page 29 of the Statement of Uncontested Facts. It is clear that from paragraph 10, that Benoru retained minority shareholding, which ranged between 31 to 38%. Members of the tribunal, this is a minority shareholding. Therefore, it is our submission that it does not qualify as a state-owned enterprise. Additionally, members of the tribunal, case law pursuant to Annex 3
Council, sorry, if I could interrupt you. There's also on the facts where Bonoru increased their shares, I believe, over 50%. How does that impact the analysis you just provided for us?
Indeed, under paragraph 65 of the Statement of Uncontested Facts, it is clear that Bonoru increases the stake to 55%. However, members of the tribunal, I shall be relying on the case of CSOB versus the versus the Slovakian Republic, whereby it was stated, members of the tribunal, that the nature and such ownership alone will not disqualify a company from filing a claim with the center just because it is a national overcontracting state. In this particular case, the facts were similar.
Wait, now you're confusing me. I thought you had said in your interpretation of the additional facilities rules, at least, that a state-owned entity would not qualify as an investor. And how, if you have a state owning a majority of this enterprise, is it not a state-owned enterprise? I got it when it was a minority, but when it becomes a majority, how have you not walked yourself into your own narrow reading of the additional facilities rules?
We are alive to the fact that under the Statement of Uncontested Facts, under paragraph 65, there is an increase in stake. Therefore, it is our submission that in the event that this tribunal would want to look at the 55% shareholding stake, then it should refer to the case of CSOB versus Slovakia Republic, whereby we see that Slovakia had 65% stake, and we see that Czech Republic had 24% stake. However, in that particular case, it was still that we should be looking at the nature of the functions and not the purpose of the function.
Okay, so then let me ask you a question about the nature of the functions, because you said earlier it was primarily commercial and the state functions were auxiliary. So you acknowledge that there's some state function in the claimant's activities. I was curious about the argument made by the respondent, who pointed out that the airline is flying a key route at a loss, which doesn't seem particularly commercial to me. I mean, commercial enterprises don't tend to do things at a loss. How do you respond to those arguments that this really is not just auxiliary, but a primary part of what this entity is doing?
I shall rely on the case of Hamista versus Ghana, where it was specifically stated that the mere actions of a state, of an enterprise being important to national interest would not necessarily prove agency. It is important to note that the economy at that time was at a downfall, and therefore there was even an oil crisis at the moment, and that is why they were flying on routes that indeed were loss-making. In light of that, members of the tribunal, I shall refer you to Annex 3, where in fact the state, I shall refer you to Annex 3. That would be page 43, whereby it was explicitly stated by the courts, the constitutional courts of Bonoru actually acknowledged that this is not a state-owned enterprise, because essentially they found no violation in the privatization of Bonoru Air, because this is not a state-owned enterprise. In light of that, members of the tribunal, I shall therefore proceed to
move on. Before you move on here, I just want you to walk me through how we should consider this evidence. I'm not sure what Annex 3 is. If you could just explain to me where it came from.
Indeed, Madam President, Annex 3 arises from the Statement of Uncontested Facts, where we see the people of Bonoru go to court in order to determine on whether the people of Kyoshi's Council of the Island of Kyoshi versus Bonoru, and they determine whether there has been a violation of the mobility rights under Article 70. And indeed, the court found that the privatization of Bonoru Air did not violate the mobility rights. And this is why it is our contention that the courts themselves recognize that this is not a state-owned enterprise.
I'm not sure that it says that, but when you drew my attention to Annex 3, it kind of got me thinking about something else. That given the constitutional right and the reason this coupled with the fact that they operated at a loss, don't you think it's what you just pointed me to more supports the respondent's position that the airline is operating a government function because of the constitutional requirement the Bonoru has to its people?
The relevance of the constitutional decision would be that it essentially accepts that yes, there has been a privatization, and despite the privatization of Bonuru Air, there has been no violation of the mobility rights, and essentially goes back to the argument that the nature of the purpose, despite these activities, the public activities being auxiliary, they are still commercial in nature. In light of that, members of the tribunal, I shall go ahead to address the second issue in light of the amici submissions. Firstly, it is our submission that we shall be relying on Article 41.3, Article 37.2 of the ICSID arbitration rules, as well as the SEPTA and Article 919. They provide that, firstly, amici submissions must assist the tribunal. Secondly, they must be within the scope. And lastly, they must have significant interest. In light of this, in response to what the respondents have claimed, it is our submission that the CBFI have fulfilled their duty of disclosure. This is because under the amici submissions, they have explicitly stated that they represent 38 members. And additionally, they have explicitly stated that they are in relation with the La Presse Capital Limited, they are affiliated to them. It is important to note that the tribunal in Eli Lilly versus Canada stated that disputing parties' membership to a party does not mean lack of independence. If I may indulge this tribunal, I see my time is almost up. May I request for an additional 1 minute?
Yes, 1 minute. Thanks.
Can I ask one question regarding this amicus submission? You know, as far as I understand, respondent's argument was that not only the members of the association, but they brought separate claims against the hosting country. I might be wrong, but if right, can you address this? You know, an impact of how it impact the independence of amicus.
Indeed, Mr. Arbitrator, it is our submission that the external advisors on the external advisors CPRU have brought a matter that is outside the scope of the dispute. And this is why, indeed, pursuant to the case of United Parcel Services of America versus Canada, it was said that questions of jurisdiction are not among the matters that amici should raise. And this is why it is our submission that this would unfairly prejudice the parties, as essentially we would have to stay these hearings, and as well as it would unfairly burden this tribunal because this is essentially matters outside the scope of the disputes. In regards to submissions of the CBFI, they assist the tribunal by bringing a new perspective as they represent the consortium of Bonuru foreign investors who are from different places and have different views, and therefore they would bring a new perspective. And indeed, in the case of Philip Morris versus Uruguay, it was specifically stated that similar does not mean that the perspective is the same. In light of the above, members of the tribunal, in the case of Apotex versus the USA, it was stated that submitting matters beyond the scope of the dispute would be a ground under which submissions would be denied. In light of the above, members of the tribunal, this tribunal should the consortium of the external advisors of MECAR. The consults from the tribunal submissions.
Thank you. Claimant 1, you kind of cut out at the end there for me. I'm not sure about my fellow tribunal members. I believe you concluded your submissions and asked if there were any questions from the tribunal. None for me.
None.
Okay. Case, we will move to the first rebuttal. Respondent 1.
Thank you, Madam President. In our rebuttals, we shall first begin by offering clarifications to this tribunal and then shall proceed to address the points raised by the claimants with regards to the admissibility of their external advisors. The first clarification we would like to offer to this tribunal is regarding whether state-owned enterprises are precluded from standing before ICSID tribunals. We note that in the case of CSOB versus Slovakia, ICSID decision 1999, as well as BUCG versus Yemen, ICSID decision 2017, state-owned enterprises are not precluded from appearing before tribunals unless they discharge essentially governmental functions or act as an agent of the state. However, our submissions before this tribunal are not that the claimants are a state-owned enterprise, but rather that the actions of a private investor can be attributed to the state according to the test laid out in Maffesini versus Spain. With regards to the question raised by Madam President, as well as arbitrator Stephen, with regards to at what point or what actions shall this tribunal consider in assessing whether the claimants were acting as an agent of their state, we note that in the case of Rumeli Telkom Tesla Mobile versus Kazakhstan in the year 2008, the material time of determination is the time at which the notice of arbitration is registered, being 17th November 2020, and we submit that the actions that we have relied on in proving that the claimants are indeed an agent of the state were those that were performed before this date and not those that were performed after this date. With regards to whether ownership of an enterprise is material, we note that the tribunal in BUCG stated that the corporate framework is not material in determining ownership, but whether the claimants were directed. With regards to the admissibility of the external advices, we submit that according to the tribunal in Infinito Gold versus Costa Rica, that it is the issues raised by the external advisors, that is those of ratione legis, bear a bearing on this tribunal's jurisdiction, as if this tribunal is to make a determination and it is found that the claimants received their rights through corruption, then their word rendered by this tribunal would be null and void, and therefore it would only be prudent that this tribunal admit the amicus submissions by the external advisors. And with this, I rest my case.
Thank you, counsel. Claimant 1, Sir Rebuttal.
Before I begin my rebuttals, in light of the question that was raised by Mr. Arbitrator Diakin, I shall respond that the two matters that were raised by these people of CBFI are not essentially the same. They only raise matters within the sector and not necessarily similar matters that are before this tribunal today. On my rebuttals, in regards to agency, I shall reiterate my statement that in Hamster versus Ghana, it was stated that the mere fact that actions of an enterprise are important to public interest do not prove agency. In light to the submissions that have been made by the CRPU, it is our submission that the question of outside the scope of a dispute is of greater importance than just mere public interest, because indeed, pursuant to procedural order number 3, the matters of corruption are within the cognizance of the courts in Mekar, and therefore they will be handled by the state itself. Thank you.
Thank you. So next up, we have Claimant 2 for merits and valuation, and the floor is yours.
Good afternoon, good morning, good evening. My name is Kevin Kipchirchir, and I shall be making the submissions on behalf of the claimant, Vema Holdings, under claims number 3, claims number 4, and subsequently render the pleadings for findings that this tribunal today, Madam President, should be persuaded to make. Under claim number 3, as a roadmap to my submission, I shall be submitting that. Firstly, there was breach of due process, breach of the obligation to provide, to desist from arbitrary conduct, which breached the legitimate expectations of the claimant, over and above the discriminatory conduct occasioned by the Mekari government against the claimant, and when the claimant attempted to remedy itself before the courts of Mekar, they were denied justice. On claim number 4, as a roadmap, members of the tribunal, Madam President, we shall be submitting that we are owed compensation, and that this compensation should be based on the fair market value standard, and the same should not be reduced given that the losses occasioned on the claimant are attributed to the state of Mekar and not on the claimant's business choices. Therefore, before I delve into my submissions, permit me, Madam President, members of the tribunal, to outline the context within which these violations that we bring before this tribunal today occurred. States across the globe, MECAR included, always invite investors, and this is not a new thing, to exploit their resources and make profits out of their people. However, states and investors alike are wary that states could overregulate or could overindulge in business activities of their investors. And that's why they always include, such as they have done in the SEPTA Article 99, an obligation on states to provide the fair and equitable treatment, and which provides explicitly in the SEPTA today that the state, such as MECAR, shall not deny the claimant's justice, shall not breach due process in administrative proceedings, shall not conduct arbitrary or discriminatory conduct against the claimant, and shall not conduct abusive treatment or breach the legitimate expectations of the claimant.
Just to clarify, your submissions then are 4 distinct and discrete violations of the FAT standard in Article, forgive me, 9.9. Your submission is that there's 4 separate breaches here.
Indeed, President, there are 4 breaches which singly or cumulatively taken amount to breach of the fair and equitable standard of treatment.
So in the alternative, they are seen together. That's your position?
Our position, Madam President, is that taken together or individually, they amount to violation of the fair equitable treatment, as was the jurisprudence in El Paso versus Argentina, Cristolex versus Venezuela, the tribunal's awards in those decisions. On to our first limb, Madam President, members of the tribunal, we submit that there was breach of due process in administrative proceedings. In his contributions to international minimum standard of treatment and the fair and equitable standard of treatment published with the Journal for International Arbitration, echoes the words of the tribunal in Metalclad versus Mexico, that breach of due process is where there is breach of natural justice or substantive breach of transparency.
Okay, counsel, sorry, I'm just going to interrupt you one more time. You just mentioned the minimum standard of protection. Is that relevant here? Or what kind of standard do we have in Article 9.9?
Madam President, I mentioned the minimum standard in relation to the article by Paparankis published in the Journal for International Arbitration, and the standard to be applicable today is the fair and equitable standard of treatment and Article 992 of the SEPTA.
So how does it compare then to the minimum standard of treatment? Is that the standard I'm applying? Because I know what that is in international law, but are we dealing with that or something different?
Today, we are dealing with a unique fair and equitable standard of treatment, which is qualified by the minimum standard of treatment and should be interpreted narrowly. And therefore, that will have a bearing on the decision of this tribunal and the interpretation that this tribunal should take today. Further, to my submissions, the tribunal in Techmed versus Mexico has clarified that transparency obligation is where there is ability of the investors to foresee the conduct, ability of the state organs to guide their conduct so that the investors can foresee what can be expected. I'll direct this tribunal today to Chapter 3 of the Annex, particularly page 47. If you may. Yes?
37?
47.
47, thank you.
Article 3, where the Monopoly and Trade Restrictive Practices Act is clear that the CCM can only investigate a corporation singly, which has exceeded the market share of 50%. We recognize that the CCM has a discretion, but the discretion is on the decision to investigate, not who to investigate. And the Mekari Monopoly Act is clear that those to be investigated are those a corporation singly, which has exceeded the 50% market share. Members of the tribunal, the CCM in conducting its first investigation merged the market shares of 2 corporations, Royal Nanyang and the Kaili Airways. And it is worth mentioning that, considered singly, the market share of Kylie Airways was at 43%.
Council, if I know you highlighted the greater than 50%, but when I continue reading here, it says that the CCM does have a degree of discretion if it wants to investigate lower market share, specifically that if it requires special attention. And I mean, given the facts of what was going on in Makar at that time, do you not, what would support that they weren't within their statutory right here to make an exception?
Indeed, the exception under Chapter 3 is qualified that it should be exercised in the rarest of circumstances. And I'll refer this tribunal to the arbitral award in Metalclad versus Mexico that such a discretion to exercise the exceptions should be exercised within the due process of the law. And for
why is Metalclad relevant here, counsel? Because this is the domestic law of Makar. And this is the domestic statute or the domestic laws of Makar. I'm not sure how the analysis that was undertaken in Metalclad is particularly relevant in this case.
Members of the tribunal, the analysis in Metalclad is relevant in this case because they considered situations of a discretionary measure as seen by the CCM, where they may exercise a discretionary choice to investigate corporations which are under the market share.
I have a question. Sorry, I didn't mean to interrupt.
So what then, we're assuming it was under a similar statutory regime then, is that your position that it's relevant because it was a similar statutory regime? Can you talk about the facts in Metalclad then and how they may be analogous to this case?
While members of the tribunal, the facts could not be analogous to this tribunal today, as the facts in this tribunal are relatable almost word by word to the Argentinian crisis and the decisions are arising to the Argentine Republic. The decision in Metalclad, though arising out of a different regime, different facts, are aspirational because they considered similar principles, the principles of the due process of the law and exercise of discretion such as by the CCM.
Okay.
And Mr. Bicheta had a question?
Yeah, a question and an observation. The question is, can you get me from an arguable breach of this statute to a due process violation that rises to the level that we should care about under the treaty? Because they're not the same. And so tell me why, assuming that let's assume that they got this wrong. Is that enough to be a due process violation? And then I have to observe that you said you have 4 independent grounds and then a cumulative ground. Is this your strongest independent ground? Because you're using a lot of time on a ground that isn't intuitively so strong. And it's an observation that if I were you, I would think about getting us to the strongest grounds you have.
On to the last question, may I dispose of that one first? That the violations by the Macari Republic are a chain of violations. The breach of due process and arbitrary conduct, breaching legitimate expectations, and when they attempted to remedy themselves, they were denied justice. So it would be best to follow that chain of
okay, I would just be mindful of the time because we're going to have lots of questions for you. Is this enough? If they merely got the law, if they merely misapplied the law, is that enough to be a due process violation that is cognizable under the treaty and under the FET standard that we are applying under the treaty?
Indeed, Mr. Bicheta, and this would be a misapplication and would amount to violation of due process, as this has never happened before. In paragraph 36 of the Statement of Facts, page 34, in the interest of time, I'll summarize. The CCM has never combined the market shares of any 2 corporations in their market, and therefore, this could not be anticipated by the VEMA holdings. On to my second
facts, counsel, sorry to interrupt. Are there any other facts that would shore up your due process claim or denial of justice? Is there anything else that also kind of contributed? You mentioned the chain.
Yes, indeed, Madam President. In my analysis of the chronological order of events, to show up the breach of due process, I'll rely on the breach of arbitrary conduct where actions undertaken by the CCM were not in breaching due process, were not justified and were abuse of discretion. In Crystal X versus Venezuela, Madam Bicheta, members of the tribunal, it reiterated the late Professor Shower's jurisprudence in the compendium on the ICSID, published in the Max Planck Institute, that arbitrary conduct is that which inflicts damage on the investor without any reasons or without any justifiable reasons. Indeed, Madam President, members of the tribunal, the reasons undertaken to investigate the CCM have been classified by the Organization for Economic Cooperation and Development in their roundtable papers on airline alliances to not be grounds for such an investigation, as they are within their right to do such things as mergers and to cooperate on competitive parameters such as airport transfers and check-in operations. Furthermore, the maintenance of the airfare caps by the Mekari CCM was arbitrary and was an excess of the discretion occasioned on the CCM. Members of the tribunal, if I may direct our attention to paragraph 49, page 37 of the Statement of Facts, and in the interest of time, allow me to summarize today.
Counsel, I'm just going to go back to your mention of air caps. What would be the policy reason for a state implementing an air cap? If I was following your test for arbitrariness, it needed to be applied without reason or without a policy reason supporting it. So are there not viable policy reasons for applying air caps? Because I know that they are a standard practice in the industry.
Madam President, while we do not dispute the first air caps as they did not alter our profitability in 2016, we dispute the maintenance of the second airfare caps, which do not have any reason. The reasons that the CCM had undertaken to place the airfare caps had ceased to be there.
Okay, so the initial application of the cap wasn't arbitrary, but the maintenance of the cap is?
Yes.
And does that undermine your argument in any way?
It doesn't, because the reasons for the imposition of the airfare caps had to be there for them to be maintained in any case. And given that this was no longer the case, in paragraph 49, page 37, the market share of Kaeli and Royal Nanyang jointly was at 42%, and a mathematical equation will place us that Kaeli Airways was at 31%.
Furthermore, so to make sure, sorry, I'm still following the logic here, and I just want to make sure that I'm on the right page. So if the application of the air cap in itself, as you just conceded, wasn't arbitrary, then is there any violation of the statute, the original breach that you had claimed? If the imposition of the air cap isn't arbitrary, is there a violation of the statute at all?
If
the investigation that led to the initial air cap.
Indeed, if the facts of the case had stopped at the imposition of the airfare caps and had been lifted once the conditions had stopped being there will be no violation of the FET. However, the continued maintenance of the same would breach the FET standard today, as is our submission. The reasons had passed, and the Mekari CCM is obligated to lift these conditions in page 47 when the infringement has brought to an effective end. On to legitimate expectation, members of the tribunal. Campbell in House of Cards legitimate expectation in international arbitration, published with the Journal for International Arbitration, echoes the tribunal International Thunderbird Gaming Corporation versus Mexico, that to show specific representation, to show legitimate expectation, there must be specific representation which was relied on to cover an investment and which has been breached. Members of the tribunal, I'll refer us to page 31 of the Statement of Bundle of Facts, especially paragraph 21, where we see that what was marketed to Kaeli Airways included airport, its facilities at the airport, and in paragraph 26, what was further handed down to Kaeli Airways was the fees, airport services, and discounts on landing and navigation fees at the airport. This was relied on by the claimant in paragraph 23, page 31, once again, to induce the covered investments, where the VEMA Board of Directors says that these are lucrative positions which VEMA was seeking to capitalize on. And the investigation on this ground, especially the second investigation, breached this legitimate expectation. Furthermore, The Monopoly and Trade Restrictive Act, which provides expressly that the CCM should only investigate at 50% cooperation. The investigation by the Mekari CCM of Kaili Airways, which was at 43%, breached this legitimate expectation. On to our argument on denial of justice, which is related to arbitrary, or discrimination, which is related to arbitrary conduct. The tribunal in Saluka versus the Czech Republic enunciates that there is a three-tier test to show discrimination. Firstly, similar businesses treated differently for no justified reason. The tribunal in Silverbird versus Venezuela enunciates that similar businesses connotes enterprises in similar situations or similar circumstances. Kylie Airways and Jet Green and Starwings were in the similar circumstances, the economic precipitation of the car, and were airlines engaged in the same business of providing air services. They were not granted subsidies under Executive Order number 9 of 2018. And furthermore, the minister did not give any reasons for this denial at first instance. The second rationalization by the Assistant Minister for Transport in paragraph 46, page 36, in the interest of time, allow me to summarize, did not amount to anything as they relied that Vema Holdings is a state-owned enterprise. As we all agree, my co-counsel has submitted that this is not the case. On to the last nail on the coffin for Vema Holdings, as it were, Madam President, members of the tribunal. They were denied justice when they attempted to exonerate themselves in the Mekari courts. Focarelli and enunciates the tribunal in Petrobat versus Kyrgyz Republic, the denial of justice is where there is misadministration of justice due to the ill administration of the ill functioning of the national judicial system. And this could be evidenced where there is undue delay or matters are not heard. Members of the tribunal, permit me to refer you to page 29 of the Statement of Facts, paragraph 12, where we see that the Mekari courts were underfunded due to the poor running of the economy, which led to undue delay, paragraph 44 of the Statement of Facts. Members
so just let me stop you. So you're telling us that the denial of justice was the general slowness of the judicial system for everyone. So everyone in the country has been denied justice.
Members of the tribunal, yes, the situation, the ill administration of the Mekari courts denied everyone justice, and these cannot be a ground to justify the denial of justice under the fair and equitable standard of treatment.
No, I understand. I get that second part, but let's focus on the first part. Because the court systems were this court system was slow, that's your denial of justice.
No. It is because the undue delay occasioned out of the misadministration of the national judicial organs, which did not occur.
That's a lot of that's a lot of fancy words, but you're saying the courts were slow.
Yes, there was undue delay in the determination of the matters.
Undue compared to what?
Members of the tribunal, Mr. Arbitrator, may I refer you to paragraph 44, page 46, where the claimant was seeking interim orders, interim injunctive reliefs. And I see my time is running up. Can I be added 2 minutes to conclude? Thank you. That in paragraph 44, page 46, they were seeking injunctive reliefs, and this hearing for this was only scheduled in April, 13 months later.
Okay, so it's not this courts were not a denial of justice for everyone. It was in a case where interim relief was required. The courts weren't able to handle interim relief in a way that was sufficient to meet any basic standard of justice, if I may rephrase your argument.
In judicial parlance, interim reliefs should be granted at the first instance,
or denied.
Or denied at the first instance, but a hearing on the matter nonetheless should be had at the first instance, not 13 months later. Therefore, we submit that there was denial of justice, and conclusively there was denial of the fair and equitable standard of treatment. On to our argument for under claim 4.
Sorry, I'd just like to pause you, and if I may request that you spend your last minute addressing issue 4, please, as I have a particular interest in the compensation.
Yes. Members of the tribunal, the basic principle of compensation is that the victim of any violations must be returned to the position in which they were in before the violation was occasioned to them. The but-for scenario enunciated by Spiller in Damages International Law is that they should be returned to the position they could be in today, but for the situations or the violations by the oppressor. The question to be answered today is, what is the appropriate standard between the fair market value, where the investment treaty provides for the market value? I'll direct the attention of this tribunal to the decision in Davis versus India, paragraph 205, CMS versus Argentina, and Crystal Lakes versus Mexico, paragraph 846, where in a similar investment treaty which provided for the market value, the tribunal stated that these do not inhibit tribunals such as this one from considering well-settled principles of compensation where a huge amount of loss had been occasioned to the claimant due to the violations in the statement. Members of the tribunal, we therefore submit that in light of this, we are owed compensation based on the fair market value and not the market value. And second, the compensation should not be reduced because the claimants have suffered due to Mekari's actions, poor running of the economy, that the economic crisis we are currently in is directly attributable to the Mekari state, and this has reduced our profit significantly, and therefore we can directly state that their violations and the losses occasioned to the claimant are attributable to the state of Mekari and not to the actions of the claimant in their normal business activities. On to our pleadings for findings, Madam President, members of the tribunal, we plead that you find that this tribunal jurisdiction, admit the amicus by the CBFI, find that the state of Mekari has violated the fair and equitable standard of treatment, and lastly, that we are owed compensation and fair market value standard. Thank you so much. It's been a privilege.
Okay, Respondent 2, the floor is yours.
Thank you, Madam President. Greetings, members of the tribunal. My name is Sharon Yaga, co-counsel for the respondent. In the next 18 minutes, I will speak on the merits and damages of the present case. Luck can be a double-edged sword, and the reality is that rather than being lucky, an individual may experience nothing but bad luck. The claimants, having experienced nothing but luck in the first years of their investment, went against the respondent's advice, and what followed was a series of bad luck in the form of lost profits. Despite being architects of their downfall, they contend that Mekari caused their downfall by violating their rights. Therefore, in our submissions, we will be proving that first, the respondent did not violate Article 9.9 of the SEPTA, and second, that the claimants were compensated by the respondents. Turning now to our submissions, under the merits, we submit that the respondent did not violate Article 9.9 of the SEPTA. The respondent will address the submissions in the order they were presented. In our arguments, we will be proving that first, there was no violation of due process and arbitrary conduct. Second, there was no legitimate expectation. Third, there was no discriminatory conduct. And fourth, there was no denial of justice. On the claimant's argument or the first contention that there was a violation of due process, the claimant has submitted that there was a violation of due process when the respondent investigated the claimants considering a lower market share. We submit that there was no violation as the investigation was a proportional and necessary measure. And in order to prove proportionality, we rely on the case of Total versus Argentina, an exit case decided in 2010, where the tribunal noted that that a measure will be proportional if the measures were suitable to the policy objectives behind them. Therefore, we submit that in investigating Kaeli Airways, they were achieving a legitimate policy objective that can be found under Article 9.8 of the SEPTA. And to these members of the tribunal, we guide your attention to page 76, in particular, Article 9.8 of the SEPTA, which reads that for the purpose of this chapter, the parties recognize their right to regulate in their territories in order to achieve legitimate public policy objectives, such as national security, the protection of public health, safety, the environment, public morals, social and consumer protection, or the promotion and protection of cultural diversity. Therefore, Kylie Airways, having adopted supra-competitive profits and predatory pricing strategies, was eventually going to become a monopoly in the state of Mekar. If it became a monopoly, then it would have offered inflated prices, that is in the form of air tickets, and this would have hurt consumers. Therefore, in a bid to achieve...
Council, before you move on, I'm just browsing Article 9.8, and it has some familiar language, but if you could just kind of lead me down an interpretation. Is this a customary standard? What kind of interpretation should I be giving the language of 9.8?
Madam President, in interpreting Article 9.8, it should be interpreted according to the customary international law. And therefore, we should look at respondents or the host state's right to regulate in the same manner, or you should consider the respondents' right to regulate in light with the measures that they took. And in this case, the measures that they took were meant to achieve a legitimate policy objective, that of consumer protection.
Right? Because I want to, just so I can understand your arguments going forward, am I supposed to look at this then? You said customary international law. Is this the police powers test in a different form?
Yes, Madam President. This is the police powers in a different form that comes in the statement right to regulate. And therefore, when they are achieving a legitimate policy under their right to regulate, then this conduct cannot be construed to mean arbitrary conduct. Therefore, the investigation of Kylie Airways, despite it having a lower market share, was necessary to achieve a legitimate policy objective of consumer protection.
So if it is the police powers test, there's more prongs to that test than just legitimate policy objective. So
yes, Madam President.
This is all a discussion as if we even find there was a violation. You're saying Article 8 saves you, and this is just a reiteration, and we should interpret this as the customary international law police powers. So that's the legitimate public policy objective, if I'm correct, and please correct me if I'm wrong, that's just one prong. So what are the others?
Madam President, our submission is that yes, while regulating, they were meant to achieve a legitimate policy objective of consumer protection. And additionally, in order for this, the measures that they took were proportional to achieving that objective of consumer protection. Therefore, the investigation that was done, that the claimants have submitted, was in violation of due process and in turn arbitrary, cannot be construed to entail a violation of due process or arbitrariness, since it was meant to achieve this objective of consumer protection. And additionally, if the respondents had not exercised their right to regulate, then the people who would have been hurt were the consumers, that is the people of Mekar, and therefore it was justified in exercising its regulatory powers. On the claimant's second contention, that the Executive Order number 9 of 2018 was discriminatory, we submit that the executive order was not discriminatory. Article 9.9, Subarticle 2 of the SEPTA provides that states measures that are discriminatory will amount to a violation of the FET standard. And in defining what discriminatory conduct is, the 2006 UNCITRAL case of Saluka Investment versus the Czech Republic lays out a clear analysis. That is, similar cases that are treated differently and without reasonable justification amount to discriminatory conduct. Members of the tribunal at this point take note that this is a conjunctive test. Therefore, proof of one and lack of proof of the others does not amount to discriminatory conduct. And therefore, with respect to similarity of cases and differential treatment, it is true, and we do not contend the fact that Kylie Airways and its competitors are similar cases and were treated differently, and the respondents do not contest these findings. However, the crucial question that this tribunal should consider is whether the differential treatment was justified. And in proving that the differential treatment was justified, we submit that in the 2008 ICSID decision of National Grid versus Argentina, the respondents argued that the companies were a natural monopoly, and therefore it was impossible to give them the same treatment as other operators, which the tribunal accepted. Therefore, yes, Madam President, I sense a concern.
Let's go back and deal with the facts of this case then. So to have discrimination, you need to have differential treatment. So I want just question And then a follow-up, what is the differential treatment, just exactly so I can wrap my head around it? And then why is it not detrimental? Why does it not violate the standard?
Thank you, Madam President. I will now direct this tribunal to page 36 of the record of facts, and in particular, paragraph 46, where, and I will read, over the course of the next few months, MECAR attempted to alleviate some of the airline industry's concerns. On 25th September 2018, the President passed Executive Order number 9 of 2018, granting subsidies to airlines for each MECARI citizen traveling on board. The order vested discretion with respect to grant of subsidies to the Secretary of Civil Aviation, and Kylie's Airways application for subsidies under this order was rejected by the Secretary, who did not indicate the reasons for the dismissal. However, foreign airlines such as Starwings and JetGreen were granted these subsidies. And it is our submission that yes, there was indeed differential treatment, and that JetGreen, Starwings, and its other competitors were similar cases. However, in denying them these subsidies, the respondent, that is the state of MECAR, was justified in denying them. And this is why we implore this tribunal to rely on the case of National Grid versus Argentina, which specifies that because the claimant in that particular case were a natural monopoly, it was impossible to give them the same kind of treatment as other competitors.
Impossible? It was impossible to give them the same kind of treatment?
That it will not be justified, pardon me, Madam President, that it will not be right to give them the same treatment as other operators.
Why?
Well, I was going to ask the same question. You're saying this is an analogous monopoly to the one in the cited case? Because I'm confused by that. This is a similar type of monopoly, and therefore it was okay to discriminate here. Is that the argument? Or is it a different reason based on that precedent? Or precedent's the wrong word, but based on that case?
Members of the tribunal, our case is not, there has been no proof in the facts that it is a natural monopoly. However, some of the facts allude to them becoming a natural monopoly. And in particular, we guide this tribunal to paragraph 35 of the record of facts. And in page 34, paragraph 35 of the record of facts. And the last line, which reads that by June 2016, Kylie became the only consistently profitable carrier on over half the routes to and from its base airport, Pennock International.
So additionally, so what is the argument? Because they were the only profitable airline, it was okay to discriminate against them? All right, and how does that connect to your becoming a natural monopoly argument? I'm just not following.
Thank you, Mr. Arbitrator. We submit that granting Kylie Airways subsidies at that time would have allowed them to outcompete other airlines, and therefore they would have ended up becoming a monopoly in MECAR. If they had been granted these subsidies.
Is a legal test? Because you have differential treatment, and is the perspective of whether the discriminatory treatment was a breach or harmful, is it from the perspective of the investor or the state? Because your line of reasoning, if I do agree with you, is that this is kind of from the perspective of the state, but is that relevant?
Yes, Madam President, this is relevant, and we guide you back to Article 9.8, which speaks on the host state's right to regulate to achieve a legitimate policy objective. And this legitimate policy objective is that of consumer protection. However, if they had allowed them—
But sorry, just to clear, so you're pointing, so this is in the event that there is a breach. So you almost, to rely on Article 9.8, you must concede that there is in fact a breach of Article 9.9? Or is that
Madam President, we are not Madam President, at this juncture, we are not conceding that there was a breach, and in turn, and especially that of discriminatory conduct. However, we are conceding that there was differential treatment, and in determining whether this discriminatory conduct, this differential treatment amounts to a level of discrimination, then we submit that the respondent had a right to regulate to achieve consumer protection. And this is because Kylie Airways, had they been granted these subsidies, and additionally, due to the fact that they were adopting super competitive profits, would have become a monopoly, in turn, hurting the consumers in MECAR. Therefore, it was justified.
Let me cut to the chase on this. Is this an argument that you're making in these proceedings, or can I find this in a decision made by the government that this was the reason for not giving subsidies to the claimant here as opposed to other airlines? Because you've pointed to us to something that has nothing to do with the decision by the government. You're pulling this profit line out of the background facts, but did the government articulate this reason for distinguishing between the claimant and other airlines?
Mr. Arbitrator, indeed, the government had discretion as to which companies it will grant subsidies and to which companies it will deny subsidies.
But the answer to my question is no, it has not articulated this. You're now, after the fact, explaining to us why the government may have legitimately done what it did, but it didn't tell the claimant this at the time, right?
Mr. Arbitrator, according to the Executive Order number 9 of 2018, which granted them subsidies, the discretion that was offered was that companies that would skew market conditions will not be granted these subsidies. And skewing market conditions for example, a monopoly might skew market conditions in their favor. Therefore, that was implied to the claimants that in that executive order, that if they found a possibility that they will skew market conditions, then those subsidies will not be granted to the claimant.
Okay. Can you, and just, I don't want to take too much of your time, but where is that in the record?
Mr. Arbitrator, we guide you to page 56, and in particular, paragraph C, which starts with loans and guarantees, and part B of that specific.
I'll find it. Thank you.
On the claimant's that submission, they have submitted that there was a delay occasioned by the Mekari courts in listening to the matters, which amounts to a denial of justice. We submit that there was no denial of justice with regards to delay, as first, the claimant needed to have foreseen a delay in administration of commercial decisions, and second, that the delay that the claimants contend on does not rise to a level of violation to be considered as a denial of justice. On the first element, which looks at foreseeability, what is necessary is investors' due diligence before making an investment in the host state. And this is what the tribunal, the ICSID tribunal, in the 2015 decision of Mamidol versus Albania supported. And therefore, this tribunal's point of determination is whether in investing in Mekar, could the claimant have expected their cases to be decided immediately? Members of the tribunal, to this, I would like to now direct your attention to page 29, paragraph 13 of the record of facts, which states that between 1980 and 2015, the population of Mekar grew from 6 million to 10.8 million. Its judicial system failed to expand at the same rate in this period. As a result, the average time taken from commencing an action to receiving a final decision on Mekar courts rose from 9 months in 1980 to 22 months in 2015. This was even higher in commercial matters, which took 27 months. Therefore, members of the tribunal, they should have expected that it is only reasonable that had the claimant evaluated the administrative framework, then it would have expected that the cases would have taken a long period to be had. And even though the estimated time given was 27 months, the respondent had Vema's case in a span of 13 months. And this can be seen in page 36, paragraph 44 of the record of facts, which states that while Kylie's claim against the CCM was registered on 27 March 2018, a hearing on interim measures was scheduled only in April 2019 due to high volume of cases. This shows that they not only had the case in the expected period, but also expedited the hearing. And on the second element, which looks at whether it can amount to a denial of justice, we submit that the delay occasioned by Mekar cannot amount to a denial of justice. In the tribunal's assessment, in the 2014 ICSID decision of Jandenul versus Egypt, the tribunal noted that 10 years to obtain a judgment due to complexity of the issues raised could not amount to a denial of justice, but could only be construed to amount to unsatisfactory administration of justice. Therefore, members of the tribunal, the 13 months taken to listen to the case could not amount to a denial of justice and in turn, a violation of the FET standard.
But we're talking apples and oranges. That was a case about the finality of a court judgment. This is a case about an interim measures application. So there can't be any situation in which it takes 10 years, if you're sticking with the Egypt case, to decide an interim measures application, that anyone would find that to be anything but a denial of justice. And so I'm not sure that the comparison works here. Isn't that the issue, that this was an interim measures application that should have been decided speedily to have any effect? Not the general slowness of the system, but the nature of the relief being sought here and the urgency of the relief being sought here?
Mr. President, the application or the case that was to be had was the stay on application of airfare caps. However, when the CCM imposed those airfare caps, they set them reasonably above the rates that Kylie Airways had charged on its set routes. Therefore, it was not a matter of urgency at that particular moment. And the claimants have contended that this undue delay or this delay amounts to a violation of denial of justice. However, our submission is that even though this tribunal finds there was delay, that delay cannot amount to a level of denial of justice due to the fact that they should have foreseen that those investments or that the time taken by the Mekari courts to listen to matters of commercial nature.
Okay, again, it's not a matter of commercial nature, it's an interim relief, an urgent interim relief application. They're not the same thing, but I understand the argument.
Thank you, Mr. Arbitrator. Proceeding to our submissions on damages, we submit the claimant's calculation of damages should be rejected since it is too speculative, and instead, the tribunal should apply the market value standard. The claimants have requested for $1.1 billion as the total damages, which to say the least is an exorbitant price. However, we submit that although they may rely on the most favored nation treatment clause.
That has been requested, counsel.
Pardon me, Madam President.
You cited 1.1 billion, but is that the value that is being requested?
Pardon me, members of the tribunal. Our submission is that they requested for $700 million in addition, and if this is added to the $400 million that the Mekari government paid back to the claimants at the time of their sale of the shares, then this would amount to $1.1 billion. However, the damages in question are $700 million US dollars.
So your issue is with the 1.1 billion valuation, but that is, I believe, market research available on the facts. And I just want to pause there. We're at 19 and a half minutes. I granted your co-counsel and opposing counsel 2 extra minutes, so feel free to take those.
Thank you, Madam Arbitrator. The claimants have contended that this calculation should be done using the fair market value standard. However, in using the fair market value standard, they have to look at profitability or the probability of profits. However, we submit that this probability of profits becomes too speculative, as they would not have expected that they will be gaining profits, especially in times such as that were in Mekar of economic crisis. Therefore, this calculation is too speculative to be admitted by this tribunal.
But how is it too speculative when there's market research on the facts valuating the business at 1.1 billion?
Madam President, we submit that it's too speculative since it looks at the probability of profits from the had the contended violations by the respondents had not happened. However, we submit that this probability of profits or the calculation of this probability of profits does not take into account so many factors such as that there unpredictability of prices. And for example, in the airline industry, where air tickets are not a set standard or there's no consistency in evaluating air tickets.
Can I interrupt for a second? What you're telling us that if we were satisfied that this was sufficiently strong evidence, we're allowed to look at this. So your criticism is in the quality of the evidence. You say it's weak, it's speculative, etc. But you're not challenging our ability to look at this type of evidence. You're just telling us don't put any stock in this because it's not well done, it's too speculative. But we're allowed to look if we're satisfied that this was done well at this measure.
Mr. Arbitrator, our submission, first of all, is that the fair market value standard is not a method that is provided for under the SEPTA. The proper method provided under the SEPTA, which is the law between the two parties, is the market value standard, which can be found in Article 9.21 of the SEPTA, and that is considered the appropriate standard. Therefore, even though they contend the fair market value standard, this tribunal should first find that it is not a measure provided under the SEPTA, and that even in the case that unlikely case that this tribunal finds that it amounts to a proper standard, then it is too speculative to award damages on. And therefore, the market value standard that the claimants, that the respondent relies on is the most appropriate standard, as it is what is submitted or what is found in the SEPTA. And with these members of the tribunal, we wish to rest our case.
Thank you.
Um,
Tribunal members, do you have any questions before we move on to rebuttals?
Yeah, I have a small question to the council. You know, in your statement, you were saying that the you know, Kali airline was becoming super profitable as a result of being allegedly having monopolistic position. Doesn't it undermine your co-counsel argument? It was saying that the company was operating at a loss, just from the actual standpoint and tactical standpoint.
Pardon me, Mr. Arbitrator, could you kindly repeat the last part of your statement? Yeah,
your co-counsel were saying that the company was operating at a loss in defending the argument that airline was indeed an state body, and you were saying that the same company was becoming super profitable.
Thank you, Mr. Arbitrator. Just as a point of confirmation, or just to clarify our submission, is that what I was pointing on profitability was due to the supra-competitive profits and predatory pricing strategies it had adopted due to its partnership with the Moon Alliance partner. And the loss that my co-counsel was claiming on was when they had started making losses at a particular point. However, they bounced back, if I can use that word, after a few years. And therefore, when they adopted these supra-competitive profits, that's when they started making exorbitant profits. And that is why we are submitting that they could amount to a monopoly.
I have one question as well before we move on. Considering the text of the treaty we're working with, can we consider all of the small measures the state took together to find an FET violation, or must it be one measure itself? Meaning, does it have to be just denial of justice alone as a discrete violation, or can I take arbitrariness, denial of justice, lack of due process, and find a violation?
Madam President, we submit that what should be taken is an aggregate of all the conduct together, and this is with regards to Article 15 of the ILC Articles on State Responsibility, which states that a breach of international obligation is defined as an aggregate of wrongful acts which occurs when action or omission is done. However, under Article 2 of that same ILC article, it states that the wrongful conduct, or the aggregate of the wrongful conduct, is to be found when that conduct is attributable to the state and international law and constitutes a breach of an international obligation. Therefore, our submission is that even though you take them as an aggregate of all the conducts or all the FET violations, the conduct that the claimants are alleging is not attributable to the state of Mekar, and in turn does not constitute a breach of international obligation.
Thank you. Okay, that concludes questions from the tribunal. We will turn to rebuttal. Claimant 2.
Madam President, members of the tribunal, once again, I rise again on the rebuttals on behalf of the claimant, and I'm going to raise four substantive rebuttals. The counsel for the respondent has stated to seem to justify the discrimination under the Executive Order number 9 of 2018. However, may I bring to the attention of this tribunal that the Secretary of Civil Aviation did not give any reasons for refusing Kylie's request for subsidies. Furthermore, the statement by the Deputy Minister for Transportation rationalizing the discrimination is not in tandem with what the respondent's counsel is raising today, as they discriminated Kylie Airways from Jet Green on the basis of ownership and not on the monopoly status. On the second rebuttal, the respondent's counsel seems to be justifying the ill functioning of the judicial organs of Mekar. However, these indeed in Chevron versus Ecuador are grounds for finding denial of justice as had been submitted by the claimant. And on the third rebuttal, Counsel for the respondent has referred us to paragraph 44 of the statement of facts and stated that the matter was heard in 13 months. However, may I bring to the attention of this tribunal that at that time, it was only to schedule a hearing and not to hear the matter within those 13 months. And on to the last submission, we wish to submit that the claim today for compensation is not on the value of the compensation, but on the standard of compensation, which we have submitted is based on the fair market value to be arrived at by a speculative approach they call the income approach enunciated in CMS versus Argentina. Thank you so much. It's been an unbridled pleasure appearing before us all today.
Thank you, counsel. And with that, that finishes the round and the pleading. Great job, everybody. Take a breath now. I think this is time.
Do we have rebuttal from the respondent?
Oh, sorry. Yes. Oh my goodness. So sorry. Sorry, rebuttal. I almost ended. Sorry about that. Thank you, Steve. Okay. Sorry. Floor is yours.
Thank you, Madam President. In our rebuttals, we will be answering to the 4 points that the claimant has submitted. That is that the executive order number 9 of 2018 was discriminatory and that there was no justification that was given. However, we direct this tribunal to the executive order number 9 of 2018, where the Secretary for Civil Aviation had discretion to grant or deny these subsidies. And one of the bases is on a company that would allow them to skew market conditions. Kylie Airways can be considered one of that companies. On the second element that the claimants have submitted, that is on denial of justice and undue delay, we submit that there was no undue delay, and we reinstate our submission that the claimant should have foreseen that arbitration or commercial matters will take long period of time to be had. Therefore, the expectation that the matter will be had in a short span is illegitimate. On the third claim, that at paragraph 44, which talks about a stay on imposition of airfare caps, we submit that airfare caps or the hearing on airfare caps could not be had unless the first investigation had been concluded, and the first investigation is what gave rise to this imposition of airfare caps. Therefore, it is unreasonable that they expected that the airfare caps to be removed before the conclusion of the first investigation. And on the last element, which is that the fair market value standard should be the most appropriate standard, we submit that the market value standard is the most appropriate standard, seeing that it is what is found in the SEPTA, which is a document that binds both the respondent and the claimant as they have signed that particular document. And with this, members of the tribunal, we would like to rest our case.
Thank you. Okay, now sorry about that. Now we can break. I believe the tribunal members, we will retire to a chamber and be back after we deliberate. And I close my blind. Okay.